Diane is the special counsel at Children's Law Center. She's been practicing family law in the District of Columbia for over 25 years, so she's truly an expert. And she's also a professor at Washington College of Law, American University. Thank you.
Thanks, everybody. Thanks for coming today. I often say that the lead sentence in my job description at CLC is I'm the oldest lawyer there. So I may not always know the answers, but I can usually find someone who does. I know everybody who's up here has been thanking you, but I want to add my voice to the chorus because, as I know you've heard, this is the role that you will be filling is something that is of enormous benefit to the kids, to the families, to the court. The judges are desperately in need of GALs. There are judges who would have put GALs in every case if they had enough GALs to go around. And at any given time in Superior Court, anywhere from 60 to 80% of the litigants in custody and divorce cases do not have lawyers. So, that's just kind of another layer to demonstrate why what you're doing here is so very needed. So we really, really appreciate it, and the judges really, really appreciate it, and so do the families. Because you really are someone who can take the time to hear their story. And I've learned from good judges, such as a few as there are. No, sorry. All editorial remarks should be attributed to me, not to the Children's Law Center. Cut that out of the tape. They're wonderful judges down there. Is that there are ways to treat people respectfully but still disagree and say, here's the arrangement I want, and I know that you may feel differently, but here's why I want it. And families parents and caregivers often really understand that you can agree to disagree with respect. Not always, but typically. So, on to the task at hand. I'm here to walk you through the substantive law and procedure of custody cases. So let's get started. There are three kinds of cases in which a court can make a custody determination, can enter an order about custody. Divorce cases, custody can be an issue in a divorce case. It doesn't have to be, even if they're kids, but if someone wants custody adjudicated in a divorce case, the court can do that. Or what I call sort of a standalone custody case. Somebody's filing for custody, that's really all they want. They might also ask for child support, we'll talk about that later, but essentially it's not attached to a divorce and the parents don't even have to be married. Or the third possibility is a civil protection order case. And we have a lot of materials in the manual about that. It is part of the PowerPoint. We'll see if we have time for it. It usually depends on how many questions you have. We're not getting a lot of referrals from CPO cases, so the bulk of the cases you'll be involved in are divorce and custody. If you do get a CPO case, we can train you individually. We can walk you through it. The law and procedure of those cases, the procedure of those cases is pretty simple. The underlying custody determination is based on the same law, essentially, as applies to custody in any other context, a divorce or custody case. So we don't spend as much time talking about civil protection order cases. But essentially, those are cases in which someone can get a restraining order against a family member or a parent of their child or someone else who has a particular defined relationship if some kind of crime has been committed between these two people. So it's sometimes known as a domestic violence restraining order. It's designed to address what is generically known as domestic violence. So first I want to situate you in terms of where you're going to find the law. And again, there's a lot more information about this in your other materials, but I want to give you some of the highlights. The law of custody the substantive law relating to custody between parents is primarily located in Title 16, Chapter 9 of the DC Code, especially Section 914. That's kind of the heart of statutory law relating to custody between parents. With regard to custody between parents and non-parents, also known as third-party custody, you're going to find that at 16-831.01, also known as the Safe and Stable Homes for Children and Youth Act. This is a statute dedicated to third-party custody. This statute was passed in 2007. Prior to that, there was no statute that addressed third-party custody. There was a little bit of case law, but in essence, that case law has been, to a large degree, superseded, not completely, but to a large degree superseded by the statute. And then finally, there are the statutory provisions related to civil protection order proceedings, and again, these are really, that statute's really more about the procedure and the law of getting the restraining order, not so much about custody. The custody law is in Chapter 8 and in Chapter 9, the statutory provisions. And of course, there are cases. There are not, relatively speaking, that many cases. There certainly are. There is a body of appellate case law, but there's not a ton of appellate cases, and I think it's for a lot of reasons that you can imagine, not the least of which is how many folks are proceeding pro se. But even when cases are litigated, often they're resolved at the trial level, either by settlement or by trial, but parties are, either there is nothing to appeal or parties are not inclined to appeal. So it's a relatively small body of case law. Next in terms of law are the court rules. Divorce and custody cases have their own set of rules. They're called the DC Superior Court Domestic Relations Proceedings Rules. They're very, very similar to the Federal Rules of Civil Procedure and to the DC Rules of Civil Procedure. They are not identical, however, so you always want to check the DR rules specifically if you have a procedural issue that is or may be covered by the rules. There's also another set of rules called the General Family Rules that apply to these proceedings. There's not much there that's relevant, but again, if you need to check the rules, if you think the answer to something may be in the rules, you may want to check the General Family Rules. Civil protection order cases have their own set of rules called the Domestic Violence Unit Rules. So that's where the law is. This is where you're going to be. This is the main entrance to DC Superior Court. If your case is in the morning or right after lunch, come early. There are metal detectors. There are lines. There are also other entrances that you'll come to know, but I'm very proud of this slide, so I have to show it. I didn't take it, but I figured out how to upload it, which for me was a big accomplishment. This is, I'm not going to dwell on this, but this is just, for your own information if you find it helpful. DC Superior Court is divided up into various divisions and branches and subsets, and these are really administrative divisions. The clerk's office is essentially divided the same way. I at least find it helpful to get a feel for how court is set up. And the only thing I want to mention, let me just say that you will see that divorce and custody cases are assigned to the Domestic Relations Branch of Family Court, and Family Court is a part of DC Superior Court. Civil protection orders are assigned to the Domestic Violence Unit, which is a part of DC Superior Court. And again, it's not something you really need to know, but as you start to sort of find your way around, I think it'll just help orient you. The only thing I want to mention as part of that orientation is that our judges rotate. Unlike some states, where you're appointed to be a criminal judge or a family judge or a surrogates judge or a civil judge, and that's what you are forever, our judges rotate. The rotations are pretty long, so chances are good that you'll have the same judge from beginning to end, but occasionally you do get caught in a rotation. The big rotation date is January 1st, so every once in a while your case will actually transfer to a new judge. It doesn't happen a lot, but it can happen. Alrighty, so that's where the law is, that's where the court is. I want to now orient you a little bit about what it is that is being litigated. What are the parameters here when we talk? What does custody really mean? What are the options? What's available? What can the judge do? How can you shape the outcome? Custody is typically subdivided into two components: legal custody and physical custody. Those two terms now have statutory definitions, and they're on the slides, but let me boil it down for you. Legal custody essentially means decision making, the right to make big decisions about the child. Not necessarily the day-to-day, what are you going to have for dinner decisions, but the big decisions about the child's life. Physical custody means where the child is in space and time. There are 365 days a year, and that child has to be in someone's control all the time. So essentially, it's the living arrangement, the access, the visitation schedule. It's who's got the child, or who is responsible physically for the child at any given time. I've included this quote because it sort of illustrates the interplay, the notion of what it means to have custody and decision-making and have the child with you. And it's, the lines aren't bright in terms of decision-making, but I just wanted to flesh it out a little bit. Because there's really not much else that defines either legal or physical custody in DC other than these 3 slides. So that's what custody is, the right to have the child with you or decide where the child is, and big decisions, physical and legal. So who has these rights? Well, if there's no court order, then parents have joint legal and physical custody by operation of law. I think that's really an inherent right that parents have, but in addition, there's actually a statute that says that when that child is born, both parents have equal coextensive rights to make decisions, to have the child with them. I want to note that it doesn't matter with regard to what I just said, that the child was born out of wedlock or that the father's name is not on the birth certificate. Paternity is an interesting issue, and it does come up in your cases every now and again, and if it does, we can walk you through it. But fundamentally, a father is a father, and it doesn't matter whether the child was born out of wedlock, it doesn't matter whether dad's name is on the birth certificate or not. If he's dad, he's dad, in terms of these custodial rights. So that's the state of nature, essentially. And for some people, that works either well or good enough, and they never go to court. However, the court can allocate these rights as between the parents. The court can decide who has the right to exercise which ones of these rights. And the court can also, under certain circumstances, award custodial rights to a non-parent, someone who doesn't have them inherently. And you'll see a lot more, and we'll talk a lot more about third-party custody, but in DC, there are no third parties who have inherent rights. Grandparents, relatives don't have any natural or inherent or statutory rights to custody or visitation, but under certain circumstances, the court can award them these rights. So that's the general definition, the general gist of what custody is and what the state of nature is and what the court can do to alter the state of nature. So what can the court really do? What kind of custody arrangements can the court order? So here's what the statute says. A custody order may include sole legal custody, sole physical custody, joint legal custody, joint physical custody, or any other custody arrangement that the court may determine is in the best interest of the child. That's all the statute says. It doesn't give us any more guidance than that. So what does that mean from your standpoint? Like, what do you do with that? How does that play out in the real, both in court and then in the real world? So here are, I think, slightly more expanded definitions that I think most of the world of domestic relations and custody law would agree with, most lawyers would agree with. I don't think there's anything here pushing the envelope. If there is, I'll always tell you. Joint legal basically means equal authority to make major decisions. So if you get a court order that awards joint legal custody, you kind of walk out of court with what you walked in with. And that may work fine in some situations. The battleground or the disagreement may not be legal custody, it may be physical custody. Sole legal custody, I think, is pretty self-explanatory. It's really that one person has that authority to make major decisions. Joint physical custody, I think, is completely impossible to define. I don't understand it, and I think most domestic relations lawyers don't understand it. I think if pressed, folks would say it means essentially equal time with each parent, but it is a term with no, I think, self-evident definition, and there's certainly there's no statutory definition, and the one case that talks about this is not illuminating. So I would drop a footnote and suggest then that you may want to think twice before including or suggesting that that term be included in an order, because it is inherently ambiguous. But sometimes ambiguity is not a bad thing to have. You'll have to decide, but it really is very, very ambiguous. Finally, sole physical custody is also ambiguous, but there's more of a culture around what that means, and I think that culture is pretty clearly that the child is living with the custodial parent, the parent with sole custody, that the child is spending kind of the bulk of time with that parent. That's kind of where the child lays his head down at night most of the time. Again, there's no bright line about that, about how many days or how many nights that is, but it's essentially the idea that the child is living with that parent, residing with that parent. So that got us a little closer to something more granular that we can think about in terms of what that looks like in the real world, but I want to take it one step further, and I want to ratify that, particularly because of that final provision in the statute that says that the court can order any custody arrangement that's in the best interest of the child. I want to expand the definition further by basically pointing out that the court really has broad discretion to fashion custody arrangements. So the language in the statute is very general, but you have a range of choices. And this slide is these are just the tip of the iceberg in terms of giving you some notion of the range of possibilities. And I think of it as a spectrum from very general language to very specific language. And you can have lots of general language, solely general language, or very, very specific language, or you can mix and match. For some issues general language may suffice. For other issues you may want very specific language. So I'm just giving you some examples of language that we see in orders all the time. At the general end of the spectrum, you can see you'll see the phrase joint legal custody. You'll also see the phrase shared legal custody. You'll see an arrangement that is joint legal custody with tiebreaker authority to one parent. And you might think that if there's been a custody, particularly an acrimonious custody fight, that might not be a viable option, but it's surprising how often it is. That if both parents start out with the idea that they can both take the child to the doctor, both have the right to input, that often satisfies, not always, but often satisfies both parents, but then they do understand that if they disagree, someone's got to make the decision. So you see this, I think, to me, surprisingly often, or at least it was a surprise to me how often cases could be resolved with that provision. Let me drop a footnote here. I always drop it somewhere, and this may be a good place. You'll hear all of us, and you'll certainly hear me talk about resolving a case or settling a case a lot. And the reason we do is that most cases do settle, no matter how acrimoniously they start out. Statistically, I think I'm pretty clear that they do. Settlement is not the goal, though. The best interest of the child is the goal. But it is often the case that at least the settlement you're visualizing is what you think would be in the best interest of the child, and that's where you're trying to guide the case to, rather than a trial and litigation. But I just want to be clear that when I talk about this may help you settle the case, it's not because settlement per se is the goal. It's that settlement may in fact be settlement on your terms may be what's in the best interest of the child, or settlement within a range of options may be a better alternative than litigation. Okay, so back to the language of custody and the possible arrangements. You can see joint physical custody, but with a schedule. And often, I think you see that, I think it's fair to say, because like any negotiation, sometimes language matters to people. As Rebecca was saying, these issues run deep often in terms of people's concern about children, their concern about their own self-image, things that happen to them in their own lives. And so sometimes the word sole is a buzzer word, and so the word joint will get people to a place you want to be. So joint with schedule, though, is a way sometimes of balancing how to get people to agree and yet have specificity if you think that specificity is needed about where the child's going to be or live or a visitation schedule. You see general language like sole physical custody, primary physical custody, primary residential custody. And then in terms of visitation schedules, the most general language is reasonable rights of visitation, or you may often see a basic visitation schedule, every other weekend and Wednesday nights, alternative weeks, and 4 weeks in the summer, and alternating federal holidays and mom's birthday and dad's birthday, just to give you a sense of general things. There are 11 federal holidays. Every custody lawyer, I was told early in my career, needs to know that. 11 days when children will be off school and parents may be off work. So that's the general end of the spectrum. The detail end of the spectrum, I can't give you too many illustrations because it would take the entire presentation, but it can be 1 page of detail, 2 pages of detail, 20 pages of detail. You can be as detailed as you want about any issue that you think would benefit from detail. So you could have a really detailed decision-making process. They're going to meet, they're going to confer, they're going to go to mediation, they're going to talk, they're going to do this. Mom is going to at least reach out to dad, but if dad doesn't respond, she can go, whatever will work for decision-making. And the same thing for the living or the visitation arrangements. You can say that visitation will take place starting Friday at 4:42. Pickup and drop-off will be on the northwest corner of 12th and E. The child will have her pink backpack. The laundry will be done before the child. Whatever. Like, all of that can be done in a custody order if you want. Okay, so those are sort of the options, and so which are infinite, really. The world is your oyster. You're just trying to figure out what's best for the child, and as part of that, taking into consideration, again, always subordinate to the best interest of the child, but taking into consideration how the parents are going to work within the arrangement that you're thinking about. So those are the possibilities. Now, how does the judge decide which one of those possibilities to go for if the decision ultimately has to be made by a judge? That's the legal standard. In parent versus parent, again, there's a lot more in your materials about this, but the nutshell version is that in parent versus parent cases, the paramount consideration, as the Court of Appeals has said, the legal standard is the best interest of the child. The statute says the court shall consider all relevant factors. It doesn't say much more except in the next bullet point about what is relevant, but I'm hard-pressed to think of much that isn't relevant. There are things that aren't relevant, either substantively or because they're so distant in time, but pretty much a whole lot of stuff is going to be relevant to what's best for a child. So the court shall consider all relevant factors, but as a subset of that, the statute lists 17 specific factors that must be considered. They're not exclusive, but the court must consider them. I haven't listed them because you can read them at your leisure. Most of them are common sense. They're exactly what you and I would think about in terms of what's best for a child. The fitness of the parents, any issues they have, the child's connection to other people, the child's connection to home and community and school. So many of these mandatory factors are common sense. Some of them are not, and they don't make a lot of sense, and they're not really applicable to every case, and if they're not applicable, that's fine. The judge will just say, I've considered it, it's not applicable. So these factors are important. The judges do have to consider them, and you will often see in orders the judges list the factors because they don't want to be overturned on appeal. They want to show that they have exercised their discretion appropriately and haven't abused it. But these aren't the only factors, and they don't really sort of how should I put this? Give you a sense of really how to dig into what's in the best interest of the child and how to be a persuasive advocate about it. So don't feel too constrained by them in terms of a checklist, but they will certainly give you some insight into both the judge's thinking, but how to think about what's best for a child. But these are by no means the only things that are relevant to the best interest of a child in any given case. There is a statutory presumption in favor of joint custody. So the starting point is, for the court, is joint custody. The statute does not specify whether that means legal or physical. Most judges interpret it kind of as a practical matter, as a presumption of joint legal custody, but I'm at least having an experience now where the judge seems to be more rigorous because the statute doesn't make a distinction. It just says that there's a presumption in favor of joint custody. The presumption can be rebutted. It can be rebutted by showing that it's not in the best interest of the child for the parents to have joint custody. In addition, the presumption is, in a sense, automatically rebutted, and in fact, there's a presumption against joint custody if the court has found in another case or finds in your case that the party has committed an intrafamily offense, neglect, or parental kidnapping. And all of those three things are defined as a statute. An intrafamily offense is what gives rise to a CPO. It doesn't mean you have to have gotten one, but that's what the definition is referencing. It's essentially a domestic violence, a crime. Yeah.
Sorry to interrupt.
Yes, of
Just
course.
a question. So, in our case, we have a consent CPO, so I would say that then this would not apply?
That's right.
Okay.
In civil protection order cases, it's very common for the respondents, the defendants, to consent to the entry of a CPO without admitting wrongdoing, that they just agree to be bound by the order. And so that does not, I agree, that does not constitute a finding that a crime or an intrafamily offense took place. You would have to prove that up, or the person who wants to prove it up would have to prove it up in the custody case. The presumption against joint custody is also rebuttable. Everything's ultimately rebuttable. Some judges take the presumption very seriously. Some judges don't. Some judges, it depends on the day of the week, the barometric pressure, and the facts of your case. So I think you want to feel out the situation to figure out how big a deal you have to make of the presumption, either to invoke it, if that helps you get where you want to go, or to rebut it if rebutting it is where you want to go. Okay. Third-party custody cases, what's the legal standard in third-party custody cases? Before we get to the legal standard, there's a threshold issue for third-party custody cases, which is standing. I had mentioned that sometimes judges can award custodial rights to third parties. That sometimes relates to when the third parties have standing. The third party has to have standing. So this is a list of the grounds for standing. One basis is, and standing can be alleged in the complaint. If someone disputes it, it would ultimately have to be proven, I think. So if a parent who's been the primary caregiver within the past 3 years consents to the third party filing, third party can file. If the third party has lived in the same household as the child for the preceding 6 months and primarily assumed caretaking responsibilities, that third party has standing. And the idea behind primarily assumed caretaking responsibilities is it shouldn't be the babysitter or the next door neighbor's kid who's been living in, or the au pair or something like that. It should be someone who really was not hired to do this, someone who really was sharing in the caregiving. The third bullet for standing is child is currently living with third party and there are exceptional circumstances. That's kind of the safety net general proposition. Kid is with third party now, and you prove extraordinary circumstances. The fourth ground for standing is de facto parent. That is defined in the statute, and essentially a de facto parent gets treated just like a parent for purposes of the legal standard. And you'll see what the definition is. Basically, the two individuals had to agree to hold out the third party as a parent, so that the world thinks that the third party is a parent. Yeah.
Question, for the requirement that the child live with the third party for at least 4 of the preceding 6 months, that needs to be uninterrupted?
The statute isn't clear. I would say, oh, let's see, for the preceding 6 months. Rebecca, what do you think? Does for the preceding 6 months have to be uninterrupted? The statute doesn't say, and I'm not sure the legislative history clarifies it, so I think you could make an argument either way. I think you could make
3.5 months and then you've had a week.
right, a break, and then, yeah, I mean, I think you could make an argument either way, but I don't
We
think the
certainly
law is
have
clear.
made that argument and done it successfully.
There you go. There you go. All right. So that's standing. Once you've gotten past that threshold, then the question is what's the legal standard? And the legal standard is a little bit different than in parent versus parent cases because, tick, 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 think back to con law or family law in law school. The right of a parent to custody is constitutionally protected. So that means if a non-parent is trying to take it away, the standard's a little bit higher. Now, having said that, let me say that judges grant custody to non-parents all the time in DC Superior Court, but analytically there is a slightly higher bar for a non-parent to take away this constitutionally protected right. So that constitutional protection is incorporated in essence in the requirement that what is known as the parental presumption has been rebutted. So basically it's a two-pronged legal standard. The court has to find that the parental presumption has been rebutted and that custody with the third party is in the child's best interest. The statute addresses both of these in terms of sort of the factors that the court is to consider in finding that the parental presumption has been rebutted and also in finding that custody with the third party is in the child's best interest. And you can take a look at the statute to get a sense of that. It's a fairly general language, but it does give some definition to these concepts. And again, there's a rebuttable presumption related to domestic violence. So, some helpful and or fun or both facts about custody and custody orders that you may want to know about that'll help you get a sense of the playing field, and it may actually come into play in some of your cases. Custody orders last indefinitely until age 18. So when a judge enters a, quote, final order, makes a determination, that order lasts indefinitely until the kid is 18, or and certainly unless modified. The court cannot award custody through a family court proceeding after the child turns 18. 18 is the age of majority in the District of Columbia, and the child is an adult at that point, and as some of you probably know, at that point you cannot tell your child what to do, who to live with, or make decisions on behalf of that kid. Custody is always modifiable. Permanent custody is a misnomer, and frankly I don't use it anymore because I find it a barrier to constructive conversations with parents and caregivers for them to think that it's forever. And it's really not. The court can always modify custody up to age 18. And that's usually done through a motion to modify, and indeed you may be appointed in modification situations. You will certainly be appointed in original custody cases, but you may well be appointed when someone has moved to modify. And the legal standard for modification is substantial and material change in circumstances and that the new arrangement is in the best interest of the child. The theory being there really just needs to be a good reason to change, not just a second bite of the apple or whim, but a reason, and that the new arrangement is in the best interest of the child. Custody, the primary enforcement mechanism for custody is contempt. Sometimes you also see motions to enforce the custody order. I mention that because there might be a contempt motion pending in the case in which you've been assigned. That may actually be the pending litigation, or it may be that somebody's filed for contempt and somebody else has filed to modify, and it's all roiling around and the judge is saying, help, I need help. And indeed, even if the only motion pending is contempt, that may often, frankly, be treated as kind of a de facto motion to modify, and may lead to modification. Okay, I just want to flag an issue which you shouldn't have to worry about, but occasionally does rear its head. If it does, call us and we'll walk you through it. It shouldn't rear its head because you will be appointed in a case that has already been started, so presumably someone has figured out whether or not DC is the right place for the case. But they don't always figure that out. And DC isn't always the right place for the case. The governing law with regard to this issue is the Uniform Child Custody Jurisdiction and Enforcement Act. It governs jurisdiction over all custody determinations. There's a handy-dandy interactive decision tree where you can feed in data and it will give you an accurate answer. Sometimes it will tell you your situation is too complicated for the tree, but if it gives you an answer, it is based at least on the facts you give it is likely to be an accurate answer. And I just want to flag the basic principles. The basic principles are that only one state at a time has the right, the power to make a custody determination. There's an analysis if this is the very first custody determination, the initial proceeding. There's a different analysis if you're modifying the order. And again, I'm not going to walk you through the gory details. If you need to be walked through them, we are happy to do that. I love UCCJEA issues. These are red flags. It doesn't mean that DC doesn't have jurisdiction, but it's the kind of situation where it's possible that DC doesn't. If the child has lived in DC for less than 6 months, if there's a previous custody order from anywhere, but certainly from somewhere else, which puts you into the modification analysis, and if the parties live in different states. Again, it doesn't mean DC doesn't have jurisdiction, but it's something to think about. And I don't know if we're currently including this in any of our hypotheticals, but it's one of the interesting challenges of being a GAL. If you spot a UCCJEA issue and no one else does, what do you do? So I will leave you with that interesting thought. Reasonable minds differ. So that's the substantive law. I want to walk you through the basic procedure. I'm going to kind of take you from the beginning to the end, even though you're going to probably start somewhere in the middle, because the case will have already been initiated, but I at least find it helpful to know what came before, as well as what's going to come after my appointment. Divorce and custody cases are heard, and I'm going to focus on divorce and custody, not on civil protection orders for this section. Divorce and custody cases, again, are heard in the Domestic Relations Branch of Family Court of DC Superior Court. There is a clerk's office for the Domestic Relations Branch, for Family Court actually, it used to be separate from the Domestic Relations Branch, but it's not anymore. The physical location of the clerk's office is room JM 300 in the courthouse. That's where the file room is for the hard copy files. In addition, there is a part of the clerk's office called the Family Court Central Intake Center, room JM 520. It's not actually a room, it's a gigantic counter, tastefully decorated in purple and lime green. It's a filing counter. And all pleadings are filed through and processed by CIC. However, because you're lawyers, you are going to have to e-file. And we have handouts on e-filing. I actually managed to master it, which means it's got to be pretty simple. And we can walk you through it. You have to register, and after that, it's pretty self-explanatory. And we've got a lot of pointers about it. I just want to highlight, e-filing is not like the federal PACER system. It is true that any pleading that is e-filed, you can see through the e-filing system for a while, but it's not like every pleading is online or the docket's online. So for example, if you are litigating against pro se litigants do not have to e-file. And so none of their pleadings will be on this system. It's called Case File Express. You'll only be able to see stuff that was e-filed. Similarly, if another party is represented by a lawyer, the system will e-serve them, but pro se litigants, you have to serve the old-fashioned way. The flip side is orders will be e-served on you. You'll get a nice little email that says, something's been put on Case File Express from Judge DeToro, and then you log in and you can see it. So again, I'm kind of giving you a very spotty explanation. It's really pretty simple, and we have more materials about it in the manual. And Case File Express is pretty supportive. You can call them anytime, you can email them anytime, they have stuff. so that you can access to help you through it. But it's a pretty simple system. So here's the life cycle of a domestic relations branch case, a custody or divorce case. And we call them DRB cases because they're filed in the domestic relations branch, because you'll see that the case numbers are DRB. It'll be 2014 DRB 1234. So they're colloquially known as DRB cases. A complaint is filed. The court schedules several things immediately upon filing. If custody is involved. One thing is the very first court hearing, the initial hearing. Another thing is the PAC session and the mediation intake. I think folks have talked about that. And then the case is assigned to a judge at the time of filing. So the plaintiff will walk out with a notice that has all of this information. Then the plaintiff must effect service on the defendant. Then the defendant, in theory, has to file an answer. If the defendant doesn't answer, the plaintiff can file for default and the case can go ahead anyway. I mentioned that in particular because it's true that in most of your cases, the defendant will have appeared and will be, actively contesting some aspect of the case. But we do get requests for GALs sometimes from judges when the defendant hasn't filed an answer, when it is a default situation, when there's something that is puzzling about that to the judge, or the judge wants a little bit of information marshaled to ensure that everything really is copacetic. So we do get, default situations, and often once you're involved, it turns out that really it's not default at all. It's just that the defendant didn't get his or her act together to come to court or file an answer for a variety of reasons. And I don't mean that in a demeaning way. There may be good reasons, there may be confusion, there may be bad reasons, but for whatever reason, the defendant didn't appear, but in fact does not wish the outcome that the plaintiff wants. So the first hearing in most cases, sometimes there are emergency temporary custody hearings, but the first hearing in most cases is what's called an initial hearing, and it's basically a status hearing. The court is finding out, has the defendant been served? Has the time elapsed for filing an answer? Has an answer been filed? The court also often makes temporary decisions at the initial hearing, and I know you have or will talk about these things that are that can happen over the lifespan of a case. Temporary custody and visitation orders, which can themselves be modified prior to reaching a final decision. Things the court can order in aid of generating information that may be valuable to both you and the court. So that's what an initial hearing is like. The court is getting some sense of where things are at and how to move the ball forward to resolution. You may very well be appointed after an initial hearing, because that's when the court is getting a sense of usually the first opportunity for the court to get a sense of what's going on in the case. Another kind of hearing that can take place in a case is a status hearing. Judges often set status hearings in these cases instead of proceeding sort of on a straight and narrow path to trial. There are all kinds of reasons for that. So you may be appointed after a status hearing, and you certainly may experience status hearings. Again, as an advocate, as a GAL, you can, once you're involved, you can decide whether further status hearings would be helpful, whether you need more time to investigate, to work with the parties, to let things percolate, or whether you think it's time to push forward to a resolution, that would be the more helpful way to proceed. I think most of our judges, even with pro se litigants now, set pretrial hearings and ask for pretrial statements. If you get to that point, we will talk to you about it. It is not typically as formal a process as in your, thank you, as in your garden variety civil litigation. It is primarily focused on just trying to tee things up a little bit for trial if possible, and exchanging witness lists and exhibits if possible, with certainly with litigants represented by lawyers. That's a lot easier. With pro se litigants, that can be more challenging. But it is at least a way of trying to organize things a little bit before trial. So, as you heard me say, GALs are typically appointed after the initial hearing or after a status hearing, but We have gotten cases where GALs are appointed after trial, but before ruling. That's rare, but we've gotten it. Again, we've gotten situations in which you've been appointed after a default has been entered. And for post-final order proceedings, motions to modify and motions for contempt, what may often happen is that the motion is filed and it's set for a hearing. The judge comes in and it isn't really ready, it isn't really ripe for a full hearing, and the judge says, I need a GAL, so the judge sets a status hearing and makes the referral for a GAL. So you could get a case in the posture of a motion to modify or a contempt motion. So what, to use an unfortunate phrase, is the end game? Cases typically resolve either by settlement or by trial. They rarely are resolved by somebody withdrawing their pleading, although that's not impossible. Settlement almost always takes the form of a consent order. That's probably what you want, rather than just an informal agreement between the parties. Again, nothing is impossible, but that's more typically, I think, what you're going to find to be the outcome you want. And by statute, the court must accept the agreement of the parties unless by clear and convincing evidence it is not in the best interest of the child. So the court can't can't just say, I really don't think this is a good idea. I would do it differently. Gotta let the parents, gotta let the parties decide. If the case doesn't settle, it will go to trial. And the trials are basically trials. There aren't really special rules for trials in family court. At the end of trial, the court is required to issue written findings of fact and conclusions of law. In other words, not just an order, but the rationale, and the judge might actually call upon you to prepare it, and frankly, you probably want to, because the hand that controls the drafting rules the world. Let's see what my next slide says. Right, we already talked about this. What happens after, a complaint for custody is resolved? You could be involved in that litigation. Yes, okay. So, I always feel constrained to point this out, and some folks here were commenting on this who are already involved in a case. I think it is fair to say that family court can be more informal. Decisions can be made without written motions. Decisions can be made without evidentiary hearings. Sometimes people don't pay attention to the rules of evidence. However, I also have to say that it's difficult to predict when it's going to be informal and when it's going to be formal. We can help you predict a little bit in the context of your individual cases. There may be clues, and we're happy to help you, but in general, you don't know. Like I said, it's Monday, it's Tuesday, who knows. So all I can say is, like any lawyer, try to prepare for both, and whichever is working for you, that's the one you go with. And if you'd rather go down the other road, advocate. If you want more formality, try to invoke it. If you want more informality, see if you can persuade the judge to go down a more informal path. Very quickly, I just want to touch on child support, because your mandate does not include child support. The judges generally understand that. If they don't, I think you can point it out to them, but they really do understand that. But sometimes support is either part of the case and therefore may be playing a role in how the adults are dealing with things, or it's a backstory that people are concerned about that could also be influencing their choices. And sometimes if you can help surface those issues and help the parties understand how it works, that can help facilitate an appropriate resolution. Just so you know, child support can be requested when custody is requested, but it doesn't have to be. It can be requested as part of either a custody or divorce case, or folks can file a separate petition. There are laws governing jurisdiction. You don't have to worry about them. The key really is how much. That is often the issue that is playing either a visible or a silent role in people's issues around custody. Child support is basically determined by a mathematical formula. It's in the statute, but more importantly, there's a calculator that's online where you can just plug in the numbers and get the answer. And it's basically based on the parties' gross incomes. There are a few other things that are taken into consideration. You'll see them in the materials, but that's kind of the key. Just so you know, even though the age of majority is 18, the law in DC is very clear that a parent's duty to support continues until age 21 if the initial support order was issued by DC. So sometimes clarifying that certain things will or won't make a difference in terms of child support can be helpful. In particular, I think people have a distorted idea about whether the amount of time the child spends with one parent and another will tip the balance. There is a tipping point. There's one tipping point. It's something around 133 days, that if you spend more than 35% of the time with one parent, a different mathematical formula is used, and the calculator does that for you. So a few days here and a few days there probably aren't going to matter, and it's also not, there's no discretion on the judge's part. Well, I'll look like a better parent, so the judge will order less child support. That's how it used to be. It's not anymore. So I think I am literally out of time, which is both good and bad. But as always, again, we have the slides for the civil protection order. You have them, but we don't typically walk you through it. But we have finished the discussion of custody law generally, which applies in divorce and custody and civil protection order cases. So thank you. I know it's kind of a whirlwind tour, but I hope it starts to make sense. And, you know, as Rebecca said, you'll use your skills as a negotiator, you'll use your skills as an advocate. All the lawyering skills that you have, you can apply in this context, and they will serve you well. So thank you very much.
The same issues that you guys will be facing as CJL. So I'm actually filling in today for my supervisor, Kim Dalton, who meant to be here and then had something come up at the last minute. So hopefully I will do as good a job as she would.